Order. Order. Welcome, Minister, and welcome back, Ms. Alban. We saw you on Monday. We're getting towards the closing stages of our work on the government's legal aid proposals. We will have one final evidence session on the Monday that we return after the week's break to discuss with your ministerial colleague, Nick Hurd, what the rest of government is going to do about those things which might not fall within scope if you go ahead on the basis that you're currently doing. Before we start questioning, members with interests may need to declare them. I'll start on this side with Mr. Buckland.
Yes, thank you, Chairman. I've been a criminal legal aid practitioner at the bar for 20 years in receipt of payments, most latterly for criminal legal aid. I don't have any live cases at the moment.
I continue to be in receipt of legal aid funds. I continue to be a partner in a legal aid practice, so I will not be asking any questions this morning.
Mr. Sui?
I have undertaken legal aid work both as a solicitor and a member of the bar, but since April of last year I've been non-practising.
Mr. Turner?
I'm a member of the criminal bar, practice from my local chambers in Hull. I've not undertaken any publicly funded work since the general election, but I have done private paying work in the last couple of months.
Ms. Qureshi, do you still have any?
Yes. And I'm a barrister, and I have received civil legal aid and criminal legal aid in the past, but since the elections I've not done any legal work at all.
And the rest of us are not lawyers. Mr. Gunn?
Thank you, Mr. Rowan. Minister, the need for cuts aside, what is your assessment of the legal aid system as it stands?
I think that what has obviously dominated the proceedings in some ways has been the need for cuts. But I think your question is a very important one because despite the need for cuts, we do fundamentally believe that the legal aid system needs reform. We believe that there are significant inefficiencies in its delivery. We believe that it needs to be more directed towards helping the most vulnerable. And we also believe that in many circumstances there are non-lawyer and non-judge alternatives that should be better exploited. So I thank you for bringing the issue up because in some ways we do feel, looking at, for instance, the media, that too much time is being spent on looking at the proposals and not quite enough time looking at the inefficiencies within the existing system. And we have to look at what exists to move on to where we want to go.
Now, amongst some of our witnesses, there has been a ready acceptance there are inefficiencies. The Lord Chancellor predicted a tirade of complaint from many parts of the legal profession, which has predictably materialised. But in the numbers given by the Ministry of Justice, £350 million savings, and it was put to Ms Alban on Monday that this was a speculative figure. And while she didn't concede, if you don't mind me saying that, she did not entirely demur. I wonder how fixed you feel that figure might be and on what evidential basis it has been arrived at.
Well, I mean, the impact assessments provide the basis of the assessments. However, it is a middle figure, and it's not just a middle figure for the whole lot. If you can go down for each element of savings, there's an upper figure and a lower figure. So the £350 million is sort of a middle figure of all the middle figures, if you like. So it would very much depend on how things transpire. I mean, I should also point out that there's a timing issue. And that's predominantly because even if we wanted to, we couldn't bring in all of the savings immediately because a lot of them require primary legislation. So a lot of so when we say 350 million, we always say 350 million by 2014, 2015, because a lot of the savings are actually back-ended because we need to bring in the legislation. But I would also say one other thing here, and which makes consideration of the figures very difficult, and that is it's important to realise that we are not just talking about cuts here. We have as a policy objective behavioural change. We do believe that the system at the moment is too lawyer-based, is too court-based, and we want to look for alternatives. And the implications of that are very difficult to measure. I'll give you two examples. The first was when I went to a legal advice centre in the East End 2 weeks ago, and we were talking about the difference between legal help and general help, and we may come back to that later on because it's becoming quite an important issue. But when I was discussing it with them, they said, you see just across the road there's the benefits office. Very large numbers of our clients go into the benefits office, and the benefits office tell them to come here to the law centre to be told what benefits they can and can't get. Which is absolutely bizarre, because you're using legal aid to provide a fundamental benefits advisory service. Well, legal aid was never intended for that. Over the years, I say over the years, it's only been available for 10 or 11 years, but over those years it's increasingly become used as a sticking plaster for other inefficiencies within the system.
But can I pick you up on that anecdote?
Well, can I just finish that anecdote? Because then before I go on to my second anecdote, I will let you in. But let me just finish this anecdote, because when they go to that benefits office, they should be getting proper advice on what benefits they're entitled to. So we need behavioural change within government, and that's why the MOJ has been taking this issue up very seriously, I can tell you, with work and pensions, to make sure that we get those changes. I'm going to give another example, but do you want to come back on?
Well, I do, because on that anecdote, you lead me to ask the point which has been brought up increasingly, that the on-costs of that behavioural change shift to other departments, to other areas of public expenditure, have not been calculated or factored in with the Ministry's savings. So, in fact, these savings might not materialise in terms of net government expenditure because of shift to other areas. For instance, to the benefits office opposite the road from the Legal Aid Centre. How do you answer that challenge?
Well, the key is to encourage early intervention. So in the example I gave you, I'm talking about the position before we talk about general help, let alone legal advice, let alone representation. I'm saying that at the earliest stage, the money that is already being spent, no extra saving, no extra cost involved, the money that is being spent we should be doing more with that money. That's the earliest intervention, if you like, and that's often being overlooked. But it's not one that we're overlooking, I can assure you. We have a significant project with Department for Work and Pensions on that very issue. Can I mention one other good example, I think, of this? And that's of the idea of early intervention and the cost implications of that, to answer your question. And that would be in relation to family law. Now here, we're looking for £178 million savings, and predominantly we're doing that by looking to take out private family law from legal aid. And we have a policy decision there that we don't think the taxpayer should be paying for run-of-the-mill divorces and...
we are going to come back to family law later, so you have an opportunity to say.
Okay.
But perhaps...
But if I just...
But before you leave your earlier example,
yes.
Surely the department, which causes, through so many bad decisions, so much legal advice to be sought, ought to face some consequence from that. And the lack of any budgetary impact on the department, of the budgetary impact on legal aid and what you're doing, is the fundamental weakness in the system, isn't it?
Well, they do contribute to the cost of the tribunals.
But not in proportion to how many bad decisions they send.
But of course, Chairman, we are talking here about robbing Peter to pay Paul to some extent. One department of government, as far as the taxpayer is concerned.
We're talking about achieving behavioural change,
well, as far as incentivising work and pensions, yes, because we do charge them more if there are more cases coming from them. But if I can just say, from the family law point of view, the result of that. So on the one hand, we're getting savings. On the other hand, we are spending more because we're going to be investing more in mediation, but not as much as we're getting in savings. And then people say, oh yes, but you'll have more litigants in person. But from our calculations, the number of cases that we will decrease will not be increased by very much through litigants in person. So there'll still be a significant net saving.
And I'm sure,
but I do agree that all these things, knock on against each other.
I'm sure we'll come on to that. But right at the beginning, we've hit on one of the big problems that this committee has had, and it isn't the fault of this government, or it's a systemic fault really, is the complete lack of evidence and research into any of these issues that we're looking at. And we're dealing sometimes huge amounts of, huge decisions being based on one research paper from which conclusions are being drawn to justify very big decisions. Now, how does the government, A, think that it can base so much on very limited amounts of research? And B, what is it going to do in the future to ensure that the evidence base is improved so that actually decision-making can be improved as well?
Well, we are looking to improve the evidence base, and I can say that the area where this has been most felt is actually the not-for-profit area, where government knowledge was very limited. And actually, even when you speak to some of the not-for-profit organisations, the centres often have very limited knowledge of what's happening on the ground in their own organisations. So getting information has been difficult. Now, we saw this early on, and for instance, I brought this exact issue up with the CAB at a very early stage, and they did say they would provide us with evidence. Of course, the consultation closed 2 days ago, so I haven't, and I don't know what's come in yet. We've had about 5,000 responses, by the way, which we're going to be looking at very carefully, and I hope that a lot of evidence will have come in on this, these sorts of areas. Yeah.
Just going back to something I was asking you a moment ago, the point I was putting to you is really a sort of polluter pays principle, which is if as an organisation you generate a large amount of legal aid or legal help cost, you should feel the impact of that on your budget in order to create some degree of behavioural change. That's the whole basis on which the polluter pays principle works. Is there scope for that within the government system, or is it too radical scope?
Well, there are elements of polluter pays within the system as it exists. Say, for instance, costs. I mean, court costs is technically polluter pays. If you lose, you pay the other side's costs. So there are, and the problem we have within government, and we do have charging systems between departments. So, for instance, if DWP are giving us more tribunal cases, then they will pay for that. So they have an incentive not to do so. So that does exist within government. The problem as far as the taxpayer is concerned, though, is that there's no overall, not necessarily an overall net savings to the taxpayer. And indeed, if you have polluter pays outside of government, then it's possible that the taxpayer could pay more if it's government who's been doing the polluting. So you can't necessarily say that a polluter pays principle is going to have a better result for the taxpayer. I mean, there have been alternative proposals. I don't know what's in, and by the way, I can't discuss what's come in on consultations, but I remember about 3 months ago, the Law Society was talking about a polluter pays principle in terms of having some kind of levy on alcohol, that would go towards lawyers. And I think, Mr. Chairman, you saw what the tabloid press made of that one, sort of a penny for lawyers. And of course, these things are seen as a tax as well.
Not wholly influenced by the tabloid press when you reach
not
conclusions on
not at all.
decisions?
But they can be seen by, I would say, the taxpayer as a tax rather than a levy.
But we had another example given to us in evidence in the area of special needs education, where over 90% of appeals were successful. And if that is happening, there's clearly something wrong with the decision-making process, and money which might have been better spent on looking after the children in the first place is being spent on legal processes to overturn nearly every decision.
The key here is early intervention, and this is a very much a policy objective of the current government. In DWP, we want better decisions to be taken at an earlier stage so that less appeals come through. In relation to employment tribunals, I've just put out a consultation document together with Ed Davey in BIS, where one of the proposals is that we're looking that all cases should go to ACAS before the employment tribunal to try and sort out the issue before lawyers are even needed. In relation to special educational needs, we're looking at education rather, are looking at a possibility of mediation pre-tribunal. So many of these areas we are now switching to looking at early intervention, which is the key.
Elizabeth Truss.
Minister, I just wanted to address the point on polluter pays,
Yeah.
which you were essentially saying that there would be a zero-sum gain if it just transfers from one department to the other. But isn't it the case that DWP costs, if they actually sorted out their system and reformed it so it worked effectively, that would save money in the long term? And paying high legal bills in the short term might incentivise them to do that. And I think we're comparing the cost of lawyers compared to the cost of personnel within the DWP getting it right first time. And certainly as an MP, I experienced a lot of the DWP getting it wrong the first time. And the greater pressure that can be put on the short term will result in a long-term saving.
I absolutely agree that we have to get DWP to do more right earlier on, and we are working on that. In the short term, I have to say, from the department's point, from the Ministry of Justice's point of view, we have to provide a service, and the service is making sure that people who want to have their benefits decided have them decided within a reasonable period of time. Now, because the benefit system is rapidly changing at the moment, we are getting an increase in appeals. And that will take a year or two to calm down until we get into the new system. So we are seeing a spike in appeals, and that has meant, I'm afraid, that in the short term we have, as a department, had to respond to that to make sure that people get their benefits within a reasonable period of time when they're entitled to them. So we have, I can tell you, increased the number of medical advisors on the tribunals by, I think, 170 in the last few months, and we've also increased the number of judges by 20. We did have a backlog on this, and we're now in a position where I can fairly confidently predict that we will get back to normality within the end of the year. So we are on top of it. But you do have to deal with these issues as they come up, and we are dealing with it.
Wouldn't it be cheaper for the DWP to have dealt with those issues rather than it going to another department, having all these additional costs and experts involved, if it was just a systemic failure of DWP to get it right in the first place? It strikes me that we've experienced a ballooning in cost because the process hasn't been got. And will DWP be charged for those extra people that you've just been discussing?
The tribunal costs, yes.
But the extra advisors, will they be charged for?
Well, it forms part of the tribunal costs, and so the answer is yes. But I think there's two issues here. Firstly, there are historical systemic problems that you're talking about that we are addressing. And secondly, there's the fact that we're significantly changing the benefit system. And I think that would have had a lot more people appealing, whatever the systemic issues are. And I think so. There are two issues there. But ultimately, that's a good question to put to DWP as much as me.
Can I raise a slightly different point, but related one, which is that in civil legal aid, the cost of funding representation is more than double the amount that's actually spent on help. And it appears least possible that if the balance was different and help was provided in more cases, then some of the needs for representation might be avoided, and that some of the help that is needed is not necessarily even qualified lawyer help, but specialist advice, if one takes areas like housing, for example. If that specialist advice isn't available, then it pushes up the amount of representation that takes place because more cases go to court. The balance between representation and help.
Yeah, I mean, that's a very important issue. Of course, Chairman, you made the distinction between, you said civil, presumably as opposed to criminal.
Yes.
But actually within civil, the positions are very different. So, for instance, if you take welfare law, most of the money goes on help. If you take family law, most of the money would go on representation. So actually, you have to look, and actually within those areas, you probably have differences as well. So it's not, you can't look at it quite like that. But yes, we do. I mean, just going to the highest level, we do believe that we have had to relook at the system. Given that we have to put in place cuts, given that we want to make an efficient system, we have relooked at the system to decide where the help most needs to go to help the most vulnerable based on our criteria, which is if someone's liberty or security or their home is in immediate risk of repossession, then they are priority issues. And less priority issues are where people are looking for damages or to increment their income. Not that those are not important issues for those people, but in terms of priorities, and I'm afraid government does, we do have to prioritise. We do have the most expensive legal aid system in the world, and we do not believe it's sustainable at the current rate. And that means that we have to look for savings. That means we have to make priorities. But I would like to take this opportunity, Chairman, if I could just finish, because there's been a lot of confusion on this area of representation, and I would like to take this opportunity, if I may, just to clear this up. And there have been a lot of press comment and articles. I'm looking here at the Shadow Justice Minister. He did an article. I have to say, Mrs. Grant wrote a letter in The Guardian which made the same point. And the point and the misconception in all of these is that in benefits legal aid, that legal aid currently pays for representation. This is a common mistake, and I'm seeing it again and again and again, and it's sort of getting a life of its own. Let me make it quite clear. At the moment, people do not get legal aid for representation, for benefits, in either the lower tribunal or the upper tribunal. And by the way, the cost, we reckon, of providing that would be about £500 million. So I just think, I'm very prepared to have a rational debate about any of this, but in some areas, the debate is getting out of the bounds of reality, and I just think we need to pull it back a bit, and I'm pleased to have that opportunity.
Mr. Turner had a supplementary question.
I'm very grateful, Chairman. Minister, I really must pick you up on this. You've suggested that you're very keen to protect the most vulnerable, but the reality is you're taking debt, housing, immigration, welfare cases all out of the scope.
No.
How is it possible?
Incorrect.
I'm sorry, I think I was anticipating a question that I was going to come to with Mr. Evans after Ms. Qureshi dealt with family law. So could we just leave that until we come to that?
Okay, Chairman, thank you.
Yasmin Qureshi.
Well, can I just...
Sorry, I'm going to give you an opportunity to talk about all that. I just wanted to do it in an orderly fashion. Yasmin Qureshi.
Minister, you started off by saying that you visited a law centre in which you were told that people were having to advise people as to what benefits they can have. So are you suggesting that perhaps most of the law centres and citizens' rights bureaus are giving people advices on benefits they can have? Are you seriously saying that's the case? Because I can assure you that as one who's done a lot of work for the Free Representation Unit and for law centres, at no time in my 20 years have I ever advised anyone on what benefits they can have. It's been about when they've been refused something and they've been advised on it.
Well, I mean, let me start by saying that that I, and indeed the government, very highly values not-for-profits, and I agree that they provide very frequently a fantastic service to vulnerable people. I mean, that's not the issue. But at the same time, the reality is that people who should be receiving general advice are getting it paid for by legal aid, and that in a state of affairs where we have to very carefully ration and look at where we're spending our money is not the right way to go. In effect, legal aid has often become a sticking plaster for the problems that came into the system. What do I mean by that? When about 10 or 11 years ago, the last government decided to allow not-for-profits to use legal aid, because before then they weren't allowed to, at that point there should have been a review of the entire sector, but there wasn't. And the result is that money is being inefficiently spent. There's huge duplication of services across the sector, and there are significant inefficiencies. And I'm afraid that now that the money is not there anymore, and we're have to look very carefully at how we spend the money, all of these inefficiencies are suddenly coming out of the woodwork. Now, are we going on to not-for-profits later? Or,
yes, we are.
So we can discuss that in more detail.
We'll try to turn to family law.
Just to make the general point to answer Mrs. Qureshi's question.
In relation to provision of legal aid, the Green Paper states that the provision of legal aid in private family law is creating unnecessary litigation and encouraging long drawn-out and acrimonious cases. Can I ask, Minister, what is the evidential basis for that assertion?
Well, I mean, this is in family, is it? Or
it's family.
Yeah. Unnecessary litigation. We do believe that. I mean, let's firstly realise that in family law, 90% of cases don't go to court. 90% of cases, people agree how they're going to proceed as far as their divorce is concerned, as far as their family assets are concerned, as far as contact with their children is concerned, without a court. They will sit down and agree. The question is, what happens in those 10% of cases? Now, at the moment, we are providing a very significant amount of legal aid for people to go into courts to decide whether, for instance, a child should be picked up on a Wednesday by one parent, or whether they should spend one holiday or another holiday with one parent. And we fundamentally think that is not a priority for legal aid. Again, I'm not saying it's not important for the family concerned, but we're saying that for the most part, from a policy directive, those people should be deciding how they run their own lives. And we, as government, are prepared to help them, which is why we're going to significantly increase the amount of spending on mediation, which is proven to be quicker, cheaper, less contentious, less adversarial, and actually where the parties buy in to the result, and rather than having a judge telling them what to do. And that is why in those cases where people haven't decided, we want them to certainly look to see whether mediation is appropriate in the first instance.
Resolution has told us in a committee hearing that without targeted funding for early advice on all non-court options, parenting information or solicitor negotiation, the court could, in fact, become too easily the first point of call rather than the last course.
Well, I mean, in 90%, that's simply wrong in 90% of cases, and I can't see how that's going to change. So we're talking about that 10%. So I think that's a huge exaggeration to start with. But there will be cases where people do not agree. I think when they're on an equal playing field in terms of not getting legal aid, they will be perhaps more interested in taking the mediation alternative, and that's something we would certainly encourage. Some of them will end up in court as litigants in person. They do now. And I think this is an important point, actually, Mr. Chairman, because people often take the existing system as a fair one. But we need to appreciate that for many, and I'm not just talking here about Fathers for Justice, I'm talking here about many thousands, perhaps tens of thousands of people who are going through the court system at the moment and are feeling prejudice and unhappy with the system. And this isn't coming out. And I just thought, actually, that this email came in to me on the 4th, and I've got another one here that came in on the 8th. If I could I think it will be of interest to the committee, Sir Anne.
Depends rather how long it is, because we have a lot of questions to ask.
Well, it's not very long. And let me just read
I'll
this.
be the judge of that.
Yeah. Okay, so the woman, I want to draw your attention to the actions of my ex-husband, who has been in receipt of legal aid since April 2009. He has a dispute with me over contact with our 2 children. Because of his serious mental health problems and his abusiveness towards me, I've obtained a controlled contact order. Despite having contact 7 to 8 weeks for a whole day, he takes little notice of court orders and continues to bring new hearings at the family court and harasses me. This is, of course, extremely detrimental to my family's peace of mind. So far, there have been 5 hearings. He is supported by at least 2 solicitors and once a barrister.
I think we've got the message.
Yeah. Just the end of the story. Sir Anne, the end of the story.
Most of us have received a wide range of very similar emails in the course of our work. I take it you're making the point that a legally aided litigant in such cases can place someone who's not legally aided at a disadvantage. And
I'm making the point, Sir Anne, that this case has cost her parents £30,000 because she can't afford it herself. She's not entitled to legal aid. And I'm also making the point that these are coming in to me at a very rapid rate, and that the idea that the current system is fair is hotly disputed by many thousands of people, and I don't think that's coming out.
Yes, Ms. Crash.
But, Minister, can I ask you, has any research actually been carried out on the impact of removing legal aid funding from private family law cases, on the number of cases reaching court? Because one thing for you to give your opinion about it, but has any research been carried out by the department?
Yes. HMS management information shows that in 2009-2010, so this is very current, divorce cases where both parties were represented took over 50% longer on average than those where neither were represented.
Right.
So legal representation, we can have a debate as to whether it's fairer or not, but it's certainly slower. Which, by the way, runs totally contrary to a lot of the anecdotes that we've been receiving, that if you don't have legal representation, cases are going to take longer. Our evidence is showing that it takes 50% shorter.
But have you looked at the impact of removing this legal aid funding from people? What would the effect on people if you took legal aid away from them?
Well, on the basis that they're not represented, I certainly don't think we have any evidence to show that cases are going to take longer.
No, but what I'm trying to say is that if you're taking away somebody's legal aid on these family law matters, but no one, it seems from the department, has looked at the impact of what would have on the people when you take the money away. Has any research been carried out on that?
Well, I think it's hard to research what would happen when it hasn't happened yet.
Can I just get one further point which we do need to have cleared up? Do you want to deal with it or shall I?
Yes, and just the, according to the proposals, individuals who've experienced non-physical domestic abuse at the moment are not being qualified for legal aid. Can you clarify for us how you define domestic violence?
Well, domestic violence, the proposal that we have for the definition of domestic violence is stated in the consultation document. I can tell you that in the consultation meetings that I've been having, this has come up as an issue very frequently. We can see it as an important issue, and it's one that we will be studying very carefully in our responses to the consultation.
So you've yet to come to a conclusion, obviously.
Absolutely.
Yes. Yeah.
Absolutely.
Mr. Evans.
Yes, you said our aim is to direct our scarce resources towards the most vulnerable. What do you define as the most vulnerable people in society?
Well, we have eligibility criteria. In criminal terms, those were set by the last Labour government. Those were set by the last Labour government, and we're not proposing to change those until we see how they work. In civil terms, we have put a set of proposals into the consultation paper, and we are changing the eligibility criteria. In certain situations at the moment, someone with £300,000 of assets, I believe, can get civil legal aid, which we think is unfair. So you know, the as to who is eligible exists.
So do you think these people are going to need help with debt, housing, immigration and welfare cases?
Well, I mean, as a guiding principle, if as I said before, Mr. Chairman, if someone's life, liberty or their home is at immediate risk, then they will be eligible.
So how are you going to direct these resources then if you've taken them out of the scope?
So how
are you going to direct the resources if you've taken them out of the scope of legal aid?
To those,
like debt and housing?
Well, to those who remain within scope.
What about those ones who are outside the scope? Where do they
you can't generalise, Mr. Evans, because in some circumstances it will be more suitable for general help. In other circumstances, we would be saying that it would be more suitable for non-court alternatives, such as mediation.
Could you give me an example? I mean, you've been very anecdotal today with stories. Could you give me some sort of example of the type of person who's outside the scope, who need, and what help would be available to them?
Yeah, I mean, I don't really know where to start. If you want to give me a particular area, then I can perhaps address a particular area. I mean,
well, if we looked at someone with whose house wasn't at risk but needed help with housing, what about them?
Yeah, well, the consultation document in that situation says that if the repairs were very serious that were required because there was a safety problem, coming back to the principle of their safety being at risk, then they would still receive legal aid. And I have to say, in relation to a point made by Mr. Turner earlier, who I think said that we were taking housing out of scope, we're not. we're reducing the scope. If someone's home is at risk, or if there is a serious security issue coming out of for instance, I don't know, the gas creating a security problem, there will still be legal aid. And I think the overall, there will still be afterwards 38 million on legal aid will still be spent on housing. We're not taking it out of scope.
And with the concerns about Citizen Advice Bureau, what about debt?
Debt is generally a matter for general help rather than legal assistance. It's bound up. It's a complicated area in relation to it being bound up mainly. It's not mainly Justice, of course, who funds it, let alone legal aid. It's mainly financial inclusion, and that's a Treasury-led one, and that comes to the end in March. I would say that dealing with debt from a general help point of view is an important issue, and if we're coming on to not-for-profits later, we can discuss it then, but it's certainly an issue that should be included in the discussions with the OCS.
I want to move on a little bit now. So, do you agree with the legal action group's belief legal aid will cease to be viable as a nationwide public service in future should these proposals go through? What are your thoughts on that?
So legal action.
Is it my accent?
No.
Do you agree with Legal Aid Action's belief that legal aid will cease to be a viable national public service if these proposals go
Absolutely. Absolutely. We are proposing to cut legal aid. But
absolutely not.
Oh, absolutely not. Sorry, I don't agree with their supposition.
I just wanted to clarify.
Thank you, Sir Alan. Yeah, I mean, you know, we are proposing to cut legal aid by 350 million, but that is off a 2.2 billion budget. In certain areas, we're not looking to touch the scope at all. In criminal law, we're not looking to touch the scope at all, for instance. So, you know, we're just redirecting resources to where we think they should be redirected to.
So what will you do to prevent legal aid deserts, should they occur?
Well, that is an important issue, and it's one that comes out of this consultation and is going to be dealt with, as we've said in the consultation document, in a standalone look as to how we take forward competitive contracting, which will firstly be done in relation to criminal law. And yes, there is most certainly an issue as to when we view how the contract should be formed, as to geographical area, as to how many firms practice in these areas, and I can assure you that one of the main aims will be to avoid advice deserts. One other important issue here that's in this consultation paper is our belief in the need for an effective telephone advisory service. This actually came up quite significantly in oral questions yesterday. But we do see an effective telephone advisory service as a way of helping those who are in remote rural areas, those who are disabled, those who can't afford transport. You know, you can call up this advisory service and they will call you back. You don't even have to pay for the phone call. And we see this as another way of, as we're directing our resources to where they're most important, getting the best advice to people. We think there's a lot to be made there's a lot that we can do through the use of telephone.
Elizabeth Truss on a supplementary point. Roll on to Mr. Turner.
I'm very interested in how you've balanced the scope issues compared to the cost per case issues, because it seems to me that when you look internationally, England and Wales had a problem on both fronts. How have you compared internationally to other common law countries in terms of the scope of legal aid provided? And also, could you talk a bit more about cost per case? Over the witnesses, we've seen quite a lot of people complaining about the inefficiencies within the CPS and Legal Services Commission. How is the MOJ actually bearing down on its internal functioning to make sure that these things are dealt with much more efficiently? So do you see cost per case as being more important or scope as being more important in terms of reducing the overall cost burden of legal aid?
They're both important issues. And the CPS currently has a review going on, and you know, they are very keen to improve the CPS service, and they're looking at various areas. But yeah, I mean, it is clear from us that on any measure, taking Northern Ireland out of the equation for this purpose, that we are spending more than any other country in the world on legal aid, and that we will still be doing so after our proposed savings. The Council of Europe data that we have suggests that our expenditure per head on the court system and public prosecutions is in line with comparable Western European jurisdictions. There is a further issue that's often brought up, and that is that the nature of our system, that is that we have an adversarial system rather than an inquisitorial system, means that the actual format of representation is more complicated because you spend longer time, lawyers spend longer time arguing.
The committee has looked at other common law countries and they have much lower legal aid costs. So have you looked at countries like Canada, for example, and what lessons would you draw from those countries? I mean, where is your ideal model?
We have had an international report. It mentioned many, many things, and I think that is something that I would like to write to the committee on separately.
It may be a document we already have.
Well, we will check that, but there are many aspects to that, but it is an important one.
Mr. Chairman.
Thank you, Chairman. In relation to tribunals, Minister, we've heard from His Honour Judge Martin, the President of the Social Entitlement Chamber, and he's, I think it's fair to say, he's got some concerns. He's told us that regardless of presenting their case, applicants at tribunals need help in preparing for them, and that without such help, cases would take longer. I wonder what estimates has the Department made of the implications of the cost on tribunals by not allowing individuals that assistance?
We don't think there's going to be a fundamental cost implication. I mean, don't forget, as I said before, there's no legal advice for representation. It is for legal help. I mean, there is an issue, of course, as to when legal help is actually required and when it's a question of general help. A lot of, for instance, benefits or debt advice or a lot of it requires general help rather than legal help. Very often the issues are very basic rather than of legal complexity.
I don't know what your vision of a tribunal is, Minister, but mine, I suspect, is very different to yours. It's a terribly complex, procedurally difficult arena. The law is extremely difficult for even lawyers to get an understanding of. Have you considered those points?
Yeah, we have. What I'm actually looking for is a statistic which basically shows, and I can't find now, so perhaps if we can send it on later, which basically shows that in the vast majority of cases, the advice is, or the issues that come up in a tribunal are of a general nature rather than a legal nature. Don't forget, tribunals are not designed for representation. They're designed for people to go there and talk in normal non-lawyer speak, and they're aimed at people being able to represent themselves.
I wonder when you were last in an employment tribunal scenario, or in fact any tribunal situation, Minister, because your view, your version of what happens there, I suspect is very different to many honourable members on this committee who have had experience in those situations.
Well, can I just make the point? People do not get legal aid for representation in employment tribunals now.
Yes, I understand that.
They may have union support. They may sometimes have pro bono support, but they don't get legal aid.
Well, I understand that, Minister, but there is a suggestion that assistance for preparing cases prior to going to a tribunal will stop. Do you not accept that there will be implications on cost? Do you not accept that by allowing someone to go to a tribunal unrepresented, who has not had any experience of dealing with this area, who has not had any help in preparing the case, very complex, very difficult stuff, is likely, in my view, to slow the system down dramatically. Would you accept that?
It depends on the circumstances. In the most complicated scenarios, I do accept it. Don't forget, in many of these scenarios, we are keeping legal aid for the most complex scenarios, or where there's the most risk. But this also misses another point, where I'm going to pull us back to the need for early intervention. And if we take the example of employment tribunals, as I've said, we have looked very carefully at this, and we see a need for early intervention before people go to tribunal, which is why we're saying that all cases should go to ACAS for early mediation review. And we think that that will give people an opportunity to sort out their cases at an early stage and in a non-confrontational manner.
Well, I'm pleased, Minister, that you speak about that, because His Honour Judge Martin also picked up on the fact that legal assistance in preparing cases also acts as a triage. It gives people an opportunity to consider things. It gives lawyers an opportunity to advise and potentially avoid going to tribunal. Do you not worry that more people will go to tribunal without having been advised against doing so?
Well, I hear what the judge says, but I have to say that we are moving to a different position, and this is a policy decision, and that is that we think that the triaging should happen before, where it can be, should happen before you get to judges, before you get to lawyers. And in too many situations...
Well, how do you propose that's going to happen, Minister?
Well, I've just told you, through ACAS
times.
in the example you gave. In family, through mediation.
And what about the inequality? People are often represented at tribunals. For example, in an employment tribunal scenario, I would guess, I'm not an employment lawyer, but I'd guess that the very, very vast majority of employers will be represented. What about the inequality of people not represented?
So are you suggesting... Sorry, is the implication of what you're saying that people should receive legal aid for representation in tribunals? I've already told you, Mr Turner, that in work and pensions alone...
Minister, well, Minister...
Can I just say, Mr Turner...
Minister, well, the chairman is in his chair. I'd be grateful to Mr Turner if the chairman directs the proceedings. The implication, Minister, is that I think that the process will be slowed down, it will be more costly in the long run, it will provide inequalities in the system, people will not be assisted with legal advice in what are very complex scenarios, and in my view, that is not fair, and it does not protect, as you say, the most vulnerable.
Mr Turner, you have switched between legal help and legal representation, and the implication, I think, of what you said earlier is that people should receive legal aid for representation. You may suggest that, but you must realise that that doesn't exist at the moment and that it has very serious cost implications. I don't know what they would be in employment tribunals, but we reckon that in work and pension tribunals it would be about £500 million. So it's very easy to talk about spending money, but if you come up with the commensurate savings...
Well, Minister, I've not suggested that at all.
Mr Gummer has a supplementary point.
Yes, I just want to make that point. Minister, I had the pleasure of listening to His Honour Judge Martin's evidence, which Mr Turner was not present for. And the main point that well, we were here and we heard we heard what the judge majored on, which was the problem in the extent of the legal guidance he had to deal with in tribunals. It's gone from a small handbook, he said when he started, to 7,500 pages over 6 volumes. I mean, this is a systemic problem that originates in the work and pension system, isn't it, really?
Yes, I mean, I'm very pleased to be able to say that on employment tribunals in particular, we have a consultation paper out just on reforming tribunals. They are too bureaucratic. People are increasingly thinking of them as unfair. And we do want to see earlier intervention before people get bogged down in all the procedure that Mr Gummer's talking about.
Mr Turner.
Can I first of all ask Ms Albin about the letter which she wrote to the chairman on the 15th of February. On Monday I asked you whether there was any evidence to show there's been a substantial increase in instructing guardians ad litem in family matters. And the response is, you say, that the Commission does not indicate whether a guardian was appointed in a matter and as such unable to provide the information. I find that rather surprising because it's clearly a cost driver, is it not?
Yes, the way the Commission keeps its data, and we are seeking this information from CAFCAS for you so that we can still provide it to the committee. But the way the Commission keeps their data, they know what solicitors, obviously, and barristers they're paying, and then they know what they're paying in disbursements. They don't in any centralised way keep data that allows them to break out what those disbursements were. So they can't separate the cost of a guardian from other disbursements in a case.
Do you think that's actually sensible?
I think it probably comes down to issues around the cost of different data systems and new data systems. I mean, I think the Commission, though, would be the first to accept that they aren't always able to provide us with all of the management information that either they or we would like them to be able to do.
Yourself by your answer, but that's unfair of me.
I'm somewhat underwhelmed by the passion of your argument. Can I ask the Minister, can I just refer the Minister to what Sir Nicholas Wall, the President of the Family Division, told us? He expected a massive increase in litigants in person, and he thought that cases will take longer and there'll be more difficult experiences in court. And he thought the Green Paper did not recognise this problem adequately. Furthermore, Sir Anthony May, President of the Queen's Bench, said some presented the cases well, but large numbers did not, and therefore increased the length and expense of court cases. You said earlier on that it was purely anecdotal that there would be some difficulties in court. Are these two gentlemen labouring under some problems of believing anecdotes, or are they relying on their own experience, do you think?
We do think that there will be an increase in the number of litigants in person, but there'll be a significant fall in the number of cases going to court. As to how far that goes, it depends on the extent of the behavioural change, which we are promoting, not least the move towards mediation. So it's hard to go firm on figures, I would say, from any point of view. However, the rise in litigants in person, we are pretty sure, will be much less than the decrease will be much smaller than the decrease in cases. Does that make sense? But I would also say that it's important in this also that we realise that litigants in person have a pretty have problems now, and that we have identified this as an issue. We have a report being commissioned at the moment on litigants in person. When's that going to be completed?
There's a file survey
but we also appreciate that they need to be given better advice on how to demystify the court process. We're looking at that, and one particular aspect of that that we're looking at is to use IT and particularly walk through IT system. You've got an IT system that you can look at that takes you through the court process. And I've looked at a pilot, and I can tell you that it's a very interesting development, and I think that it will do much to help litigants in person find their way around the system. The other point that I'd make is that if you take family law, which is what we're talking about, it's a much more inquisitorial process on the whole than other parts of the legal system. And I have sat in on cases, and very often when people are not represented now, or even when they are represented, the judge will take a quite inquisitorial approach to the case and guide the people through. So if you add all that together, I think that it's an interesting question, but one where which we'll have to look carefully out for, but I don't have concerns.
Well, it's not exclusively family, because the President of the Queen's Bench has also expressed a similar view, hasn't he? But anyway, can I just ask you, have you any estimate of the cost of the impact of an increased number of litigants in person, which is recognised in your green paper?
It's built into the impact assessment. It's built into the impact assessment.
Do you have any concerns about the ability of, for example, people with mental health problems, disabilities or drug dependency or alcohol addictions to represent themselves?
We do, and we're interested to see how people respond to the consultation on these particular issues.
But have you had any have you made any pre-assessment of this particular area?
You can't generalise. So, for instance, if you take mental health, we're proposing to keep that within the scope of legal aid in the paper. So you've got to look at it on a case-by-case basis.
So presumably you'll have an impact assessment after you've considered all the responses. Is that right?
They will be reassessed, yes.
We were also told that it would not be possible to fund, for example, drug tests or psychiatric assessments where these might be needed in a situation where there's no legal aid available in family matters, and it's to determine whether a child's safety, for example, is at risk. Is this correct?
If it's about child safety, I mean, there's a so-called Rule 9.5 issue, which has been mentioned to us by many family practitioners in the consultation meetings that I've had. It is something that we believe does need to be looked at carefully.
So, in other words, if a litigant in person requires that test to be undertaken, applying Rule 9.5, there will be public funding for that to happen?
It would it would relate to the child being represented.
Sorry, the point I'm trying to make is you've got a litigant in person in a family matter to do with a child welfare, and that parent wants a psychiatric assessment of the other parent in the interest of the child's safety, but it's not publicly funded. Will there be an application of 9.5 to cover that public funding?
I don't want to get too specific. You gave specific.
I'd like to be specific.
But my understanding from the facts that you gave is that there would be legal aid funding in that scenario.
Well, so as not to be unfair to you, Minister, would you care to write to confirm whether that's correct in due course? Because it is a very important point.
Yes, it is. I appreciate that. Thank you.
While we're on family law, you've laid quite a lot of emphasis on a shift to mediation, a wider use of mediation amongst that 10% which currently goes to court. Who's going to do it, and how's it going to be paid for?
Well, there are mediation organisations. Our view is that the initial demand can be met from those organisations, and the practice of mediation, we feel, will be developed rapidly once mediators realise that they're going to be in demand. I should also point out, Sir Alan, that there appear to be very large numbers of mediators out there, so-called sleepers, who are waiting for the call, and who, when they realise that there is a demand for mediation, will be able to come on tap quite quickly. I mean, there are issues surrounding mediation in such areas as the training that mediators should have, and these are issues that are being debated within the profession itself.
But the cost?
Well, we do see that there will be an additional cost through mediators. Our initial assessment is in the region of £5 million, but for those who are eligible for legal aid now, they will be eligible for mediation.
A quick point from Perry.
I think many of us think mediation is a good solution, but I don't think it's good enough to just say lots of it's out there, people will find it. What could you do to help signpost people to mediation, divert people to mediation? What active steps are you going to take to do that?
Mrs. Perry makes a very good point, and I can assure the committee that this is an issue of particular concern to me. That I think in the last, since I've been a minister, I've made some half a dozen speeches on the issue. We are publicising it. We are providing a new website, which will be on the .gov website, and people will have easy access to mediators. And in the last few months, the number of mediators across the country, also I should say, the number of mediation outlets has increased dramatically. Do we have those figures to hand? No, but we can provide.
Unless you're already sending to
yes.
Mr. Buckland.
Yes, thank you. We've concentrated on areas where scope is to be reduced, but I just want to ask a question about judicial review, where there are no proposals to reduce scope. Sir Anthony May gave us evidence a week or so ago about his potential concerns about a potential rise in judicial review cases around asylum. It arises from a particular Supreme Court judgment, I think the Card case, but I'm not sure whether they've actually determined that. And he was concerned that if the judgment went a certain way, there could be an explosion in judicial reviews under that particular head, which of course would have a big impact on the legal aid budget. I simply asked the question, I use that as an example, but more general question, is there more that we can do to look at dealing with the merits test for applications for legal aid for judicial review, and, for example, a wider public interest test when it comes to granting legal aid applications for these cases?
Well, I have to say that the starting point in our consultation paper is that we are not proposing to make any changes to the scope of judicial review at all. It being the citizens' right for redress against the state. Having said that, I note the points that you make. I look forward to resuming the consultation response from, was it the judge who you mentioned?
Yes.
We will certainly take that on board and consider it.
In your Green Paper, you refer to a number of groups like Child Poverty Action Group, Disability Alliance, Free Representation Unit, Age UK, and others I think you've talked about, like Citizens Advice Bureau, Shelter, and neighbourhood law centres. But almost all of these groups have queried their ability to plug the gap which they think will arise. So those upon whom you are relying, and many of us rely as members of Parliament, to assist in cases of this kind, are all worried about whether they'll have the critical mass to maintain the kind of advice which you envisage people would go for in the future.
Yes.
What do you say about that?
Well, I mean, firstly, Sir Alan, that although we did mention these groups in the consultation document, we did that out of respect for knowing that they were players rather than because we wanted to take their names in vain, if you like. And indeed, we have had very significant consultation and ongoing meetings with nearly, if not all of them. And I'd like to make it very clear that this is an area we take very seriously. We do see it as an important issue, and we do see it as an issue where the existing circumstances and the existing provision are not coherent enough, given the fact that there's going to be less money in the system, so that reform is required. Now, if you take, for instance, a not-for-profit, if you take CAB, for instance, the Ministry of Justice funds CAB to about 15%. So most of CAB's money locally would, for instance, come from local government, although an average CAB may have a dozen or more funding streams. There's a great lack of knowledge, as we discussed earlier, as to where these funding streams come from, how they tie in nationally. Most of their national money on CAB, for instance, comes from the Department for Business. And there is a great need to actually have a cross-governmental review of how we support our not-for-profits, how we don't duplicate services. In certain areas, particularly debt, there's huge duplication around the country. And this is something that certainly the Ministry of Justice is very committed to. I've already had a meeting with the Office for Civil Society, part of Cabinet Office, Nick Hurd, who I'm very pleased to see that you're going to be meeting with shortly. We've been in constant correspondence with him at a ministerial level, and officials are in constant discussion. Of course, it involves most of the departments of state, not just justice. But this is an area that the government takes seriously and that we're going to be looking at on a cross-governmental basis.
And finally, Mr Turner is going to ask about the consultation itself.
Chairman, yes, we're very lucky to have you here, Minister, just a couple of days after the consultation period closed. So thanks for that. I do have some questions around the consultation, and I don't know if time will permit, but perhaps you might want to put your answers to us in writing. First of all, I think you've said there was 5,000 people consulted the department, or respondents to. What type of organisations Right, okay. My concern as well is probably around the staff. How many members of staff has the department held over for considering the consultation? And is there a timeline for the responses from the department?
Well, I think just about anyone with an interest has responded. A lot of the 5,000 responses are standard form letters, it has to be said. They're not all individual responses. Some are several hundred pages long and some are one-page standard letters. And I can't give you a breakdown of that 2 days after the consultation is finished. But it is about 5,000 of them, and they will all be considered and looked at. And we will be coming back. What's the date for us coming back, Sarah?
Well, we're hoping to be before Easter.
Yeah, we're hoping to come back before Easter.
We will report, of course, before then, and we will expect you to take account of what we say. But clearly, it's going to take quite a lot of staff to absorb all that material and make sure that you've got a full and accurate summary.
This whole exercise has been a very major exercise for the Ministry, and right from the formulation of the consultation paper, we've had a very significant team on it.
Minister, I think you've said this before, but I think the committee would welcome a reassurance. This is going to be the last such consultation for a considerable period of time, bearing in mind we had 30 between 2006 and 2010.
Well, absolutely, and I have made a point of that myself, that the idea behind this consultation is that we have a composite look at legal aid across the board. And indeed, we put out the Jackson proposals on the same day so that people could look at funding not only from the state-funded sector but also in the private-funded sector. I have to say, though, there's always an exception, and that is, as is mentioned in the consultation paper, that we will have a separate consultation on the contracting, as I mentioned earlier on today, on the contracting, competitive contracting, which would be for criminal firstly.
If you don't carry out a proper consultation, you may find yourself in court subject to legally aided judicial review.
Oh, indeed, Chairman.
A final question from Yasmin Qureshi.
Minister, some time ago you said that if citizens' advice bureaus and other places close down, people can always go to their members of parliament to seek assistance. The word for that.
Did I say that?
Yeah, it was, well, I've mentioned it in the House previously, and I think it was reported in the newspaper that you suggested that somehow people should be able to go to their members of parliament. Now, my Citizens' Advice Bureau in Bolton saw 14,000 people. Are you really expecting me to be able to do with all those 14,000 people?
Well, firstly, I don't recall saying that every CAB case should go to their member of parliament. Secondly, I would hope that the committee would have understood from what I said earlier that I'm fully supportive of CABs, I'm fully supportive of not-for-profits, and I'm certainly supportive of general advice being provided by these organisations. I've said what I have said on the floor of the House. I said it in the legal aid debate 2 weeks ago. I said it in answer to a question yesterday in Justice Oral Questions, that I do hope that councils across the country do look carefully before they decide to stop support for their local not-for-profit general advice provision, and I repeat that again today.
Thank you very much indeed. We will report to you in due course. Order. Order. The public session first. Thank you very much.